Good morning, everybody. We have, my calculation, we have about 90 minutes this morning, which we may end a little early and talk among ourselves, but to talk mostly about the status of S79 and now S210, which is somewhat a successor bill to the extent S79, which, as you know, is on the action calendar for our decision as to whether to try and override. And it's no secret that from past votes, we probably have the votes in the Senate, but are a few shy in the House. I'm not sure what we're going to do. I may just postpone action on that for a little while we take testimony on S210. So S210 is a bill that is put in by the Democrats on this committee as a successor. And quite frankly, it tried to meet what we thought were the objections of the governor on S79. But that seems to be a little bit, in my mind, quite honestly, a moving target. So I'm not sure we're there yet. I'm not sure we're wanting to go there yet. But we're going to talk about that today. And we're also going to hear from Senator Brock on the amendment he put in last year that failed on the Senate floor, which as we heard from Tate Brooks the other day, is now part of what the governor would like to see. So we'll dissect that a little bit and we'll see where we can go with S210. I don't know what S210 will look like when it leaves this committee, but my guess is it will leave this committee and go to the floor fairly soon and then over to the House, and we'll see where the governor is on S210, which I am certain will be more to his liking, but uncertain whether it will be enough to his liking. But we'll see how we go with this. So what I would like to do is have David Hall, who drafted S210, try and walk us through that slowly and highlighting the changes as we've identified them, as I've asked him to draft it, and the differences from S79, but going through as a refresher the whole bill, not necessarily as in depth as we would if we hadn't passed S79, which I think we're all pretty familiar with. Is that something that's clear, David, and you feel comfortable doing this morning?
Sure, no problem.
Thank you. Why don't you proceed on S210?
Okay, sure, glad to. So good morning, everybody. David Hall, Legislative Counsel. Probably I should share my screen. Yes, is that what you'd prefer?
I think so, yeah.
It's posted on our committee page too, for people in the public who are also wanting to look at it.
All right. Well, then you have lots of options. You can follow the screen. You can play along at home, whatever you want to do. Are you seeing S210 on your screen now?
Yep.
Wrong. All right. Well, so, this bill has really the components of S79 in it, and largely, substantively, it is the same as S79 with respect to, for instance, the registration requirements and exemptions, the rental housing investment program, the revolving loan fund for purchasers. That all language is largely verbatim from S79. The first component of this, the part about rental housing safety health inspection through DFS, or the Department of Public Safety, and then Division of Fire Safety within DPS, is a little different. You'll see, rather than take the approach of S79, which is to try to lightly graft new authority onto the existing framework, this actually creates a new chapter in Title 20 that's specific to DPS and is specific to rental housing, health, and safety. And in broadest strokes, the same thing, the result should be the same here, but this tries to, in language at least, refine some of the points about, clarifying or specifying that it's complaint driven, what the penalties are, et cetera. So as with S79, this applies to rental housing as far as long-term governed by our landlord-tenant law, and then also short-term as governed over in Title 18. You'll see in new section 2677 here, the way this is set up is that DPS is authorized to adopt rules to describe standards for health, safety, fitness of habitation, et cetera. You'll see in B here, inspections. So after adopting rules, the commissioner shall design and implement a complaint-driven system to conduct inspections of rental housing. So, that's a very minor nuance in the real world, because right now what they do is complaint-driven, but this specifies in statute that the rules and the framework that they should adopt must be complaint-driven.
So can I interrupt for a second?
Please do.
I'm just going to jump in occasionally, trying to get the big picture here. This was in the governor's veto message, even though we never heard any objections during the testimony at all about this. In the veto message, the governor said that this perhaps was not a complaint-driven system, much to our surprise, because we thought we always had set it up as a complaint-driven system, but this makes it absolutely clear that it will be a complaint-driven system. Thank you.
So the rest of B, beginning here with B2, is just the current language that is, right now it actually appears in Title 18 because it's specific to local health inspectors and the inspection reports that they have to issue and what the process is there. You may recall from S79 that this language was taken from Title 18 and put into Title 20. So DPS's protocol would be the same as what you have in statute now on the health side. So this is all of that language now reconstituted in a new chapter in Title 20. This piece at the top of page 4, the penalty piece, is different. So here you'll see if the person responsible for a violation does not comply with the requirements and timelines specified in an inspection report, the commissioner may impose an administrative penalty that is reasonably related to the severity of the violation, not to exceed $1,000 per violation.
Time for me to jump in again. This again was something that surfaced in the governor's veto message that we thought we had taken care of, and in practice, I think we had, and we never heard any testimony contrary to this. But for the first time, the governor raised it with the concern that his concern was that there could be a minor violation, like a cracked window or something, and they could shut down the unit altogether and close it down. That was never our intent. So I asked David to draft it so it would be that concern of the governor could be taken care of, that the punishment had to fit the crime. Thank you, David.
Sure. So any questions from anyone about this construct? Because that's it for the rental housing health and safety inspection for now. Okay, I don't see any questions. So the rental housing registration requirement, as I said, I didn't move a few pieces around here or there just for organizational purposes, but substantively and, pretty much as far as the words used, this is the same construct and the same language from S79. It's an annual registration requirement. Tax March 1st applies to how a property was used in the prior year. It's a $35 per unit requirement. This is the same information that needs to be provided to the department or to municipality. The exceptions are the same. It's if you're already registered with another program, as long as they're communicating with each other, you don't have to double pay the fee. And the state and the towns are supposed to talk. Same with mobile homes. We have a mobile home registration requirement. If you're already registered with DHCD's mobile home program, you don't have to double dip again. The same piece here, unit not offered to general public, that was in S79. These are exceptions that you guys carved out in your work with the house. Same with 4 and 5. 6 is actually new language, non-winterized, excuse me. You know what? I want to pause on 5 as well. Actually, you know what? I'm going to pause on 4 because I think so. 4 just specifies that the registration and fee requirements do not apply to a lodging establishment as defined in 18 VSA 4301 that is required to be licensed by the Department of Health. I don't think there's any harm in having this here. I don't think the registration requirement would have applied anyway, because by definition, a lodging establishment as defined in Title 18 here does not include an STR, but I think this just is an effort to make sure it's crystal clear that this doesn't apply to a licensed lodging establishment like a hotel. It does apply to short-term rentals, and it always was intended to do so. 5, I do want to hit on 5 now that I'm looking at it. So units accessory to an owner-occupied residence. This is different from S79. So here the registration and fee requirements imposed in subsection A would not apply to a property with not more than 3 units if the units available for rent are located on or in the property of an owner's primary residence. So this is a more expansive exemption than what was available in S79. And I read, located on or in the property to mean that, if you had your own house and then you rented a couple of cabins that were also on your same land that include your primary residence, then those cabins would not be included. And that's up to a 3-unit, either building or compound, I guess. So that's something that's new. I'll flag, see if there's any questions.
So let me put some context in this. I think this section here is probably going to be, and the next section are probably going to be the heart of committee discussion. I'm just my own opinion as a prediction. The governor wanted some exceptions for mom and pop. This is one way of doing it. Tate Brooks came in and said, it sounded to me more important than that was what they're labeling as a 120-day rule. They don't want seasonal rentals or short-term rentals to be covered by this law. I'm open to discussing that. I know others are as well. This number 5 was our way of approaching mom and pop or small landlords. So that's going to be the subject of discussion. I'm not sure. They're somewhat different. The 120-day rule obviously sort of applies more to seasonal rentals, which I don't necessarily think of as the place where we have problems with substandard housing. So I'm open to hearing more, discussing that further. I am concerned, on the other hand, with if somebody, goes to Florida and rents out their home for a while, and it's just one home, that could become a substandard rental unit. So we're going to have more discussion around that. This is where we're going to need to focus. And just to get ahead of it, the bigger issue that we'll hear from Senator Brock, forgive me if I'm not trying to speak to you, deals with a much more fundamental change in the law of keeping town health officers in the mix here. And that's a bigger issue, I think, for us in terms of we want to make this a more mature professional responsibility in state government. And that's going to be a harder thing, which you won't see any changes in S210 in that regard. But this is the last, as far as I understood, the biggest concerns of the governor was mom and pop. 5 and 6 are designed to deal with that. And with that, I'll shut up and let David go on.
We are on 6. So non-winterized seasonal units, the registration and fee requirements do not apply to a seasonal unit is unheated and unavailable for rent during the winter months. Obviously, this speaks to the chair's comments concerning seasonal properties. Is that the right way to capture them? Are these the ones you want to capture? Obviously, those are discussions you will have. I will say, and I'm paraphrasing here, so forgive me for not having the language right on hand, but the current rental housing health code doesn't apply to properties that are not held out to otherwise meet the requirements. For instance, you can't rent a cabin that doesn't have a bathroom facility, and people know when they rent it that it doesn't have a bathroom facility. They can't come back then and say, oh, you violated the code because you didn't provide running water and a bathroom, and that's required by the health code. The health code excludes those when they are rented as such. So, it sort of makes sense that you wouldn't, if they're not regulated and right now under the health code, you wouldn't necessarily need them to be registered here as a function of inspection and enforcement and awareness of availability.
This exception, though, is a little broader than that, right?
I think it is. Yes, it is. I do agree with you.
Yeah, we if you recall, we heard a lot when the bill went over to the House. We heard a lot about objections. Are we covering camps? And I didn't think we were, but this, I think, makes it clearer that we're not. And I think the governor's veto message also had concern about camps. It wasn't our intention to cover, camps that didn't have heat or didn't have water. And so I hope this meets that concern anyhow, but that's why that's specified here.
Yeah. What does it mean that what are the winter months? Why is heat the trigger? I don't know. There's just how you massage this language and what exactly you want to capture probably will be part of the discussion. 7, housing provided as a benefit of farm employment was in S79. You may recall there was some discussion on this, and then a 2-3 year delay. It kind of went back and forth on whether or not those kinds of properties, that construct should be included. So for now, it's not included, and that would come online later with the sunset of this exemption. The administration is basically the same. It's DHCD that would administer the registration. 2 is the part about collecting from municipalities the data and the information they get. 3 is the same language from S79 that limits the disclosure. You basically can only give it to other state, municipal, nonprofit for the purpose of protecting public health and safety, not for a commercial purpose, and you have to require that they won't further disclose it in a way that's inconsistent with this requirement. The special fund is the same construct. It's just a place to hold the fee revenue and direct it out to the departments for the positions and the registry work. So the knowing failure to register, this is the language that was in S79. It was scaled back from its original version and then also delayed as far as its implementation. That's why it's broken out in a separate section of the bill, because it would take effect after the registration requirements. 3 is that repeal concerning farm employment housing. 4, same language here concerning 5 DPS positions with an initial amount from COVID funds to get the ball rolling, and then the authority to hire additional positions within the authorized 5 as fees come along. Same with DHCD, 1.5 positions, initial startup COVID money, and then the payment for that comes from the housing fund as the fees roll in. Section 6 is the same as 79. It's just it's moving that inspection report language over to Title 20, though the local health official authority substantively remains the same. It is still concurrent with the state's authority. Section 7 is the same as far as these transition provisions go, and shifting that authority over to DPS once it adopts rules. Sections 8 and 9 are the rental housing investment program. And I don't know if you want to go through this again. We've looked at this many times, but that's just as verbatim from S79. Same with the revolving loan fund for purchases. That's the next 2 sections. So I'm going to just skip that unless there are questions.
I have a question, David.
Okay.
So I think you wrote me something about this. I can't remember, but this is an issue. There's an issue in the VHIP program and the rental housing and the revolving loan program in terms of, we have this issue that all legislators, regardless of party, should be concerned about. And that is how we juxtapose the budgeting with the policy. And this bill established and defined 2 important new programs designed to help develop housing. And that policy was the subject of a lot of discussion in our committee in defining those programs and putting meat on the bone as to what those programs look. At the same time, the money was in and out in the budget process. And what happened is the bill like this one got vetoed. So these programs never got fully defined the way the legislature would like to do it. But there was money in the budget that had 1 sentence or 1 word saying VHIP shall get $5 million. But VHIP was never enacted by legislation because this bill got vetoed. Yet the VHIP program, and I don't know about the revolving loan fund, has gone forward. So I would just ask you if you have thoughts about where we are legally in spending money on a program that just has a name but doesn't have any guardrails or details around it.
Yeah, happy to address that.
I don't want to spend a lot of time.
Sure.
Yeah.
Well, I mean, in a nutshell, it's just as you said. There was money, $5 million passed in the budget, and it specifically said, I'm trying to pull it up, $5 million appropriated in Sec G 400A2 of H 439 to provide grants and loans through the Vermont Rental Housing Investment Program created in 10 VSA 699. Well, that program doesn't exist because it would have been created in S79. S79 is vetoed. So as you said, $5 million was appropriated for a program that was supposed to pass in another bill and did not. So at this point, it's my understanding that the administration is moving forward with implementing a program using that money. And, it's largely based on a comparable program established with CARES Act funding earlier in the session, but they're not the same. It's not the same program. It's not appropriated in the same way. I don't think there is a clear line of authority that the legislature and the governor, through an enactment, created a program that could be funded by that money. So it's a really difficult position, honestly. I don't know what else to say. I think, as an attorney for the legislative.
That's fine. That's exactly, I just want to flag the issue. I think the problem is probably even worse in the revolving loan program. Would you agree with that?
I do not know whether or not that is being implemented. So I can't comment on that. I will say that that program, no precursor to that program actually exists and had ever been created in any of the various housing or COVID bills. So there's not even a straight face argument to say that one could be or should be implemented without some authority, I think. Speaking, look, I'm, the attorney for you as legislators, and, in part that I guess extends to the legislative branch of government. And, just as an institutional matter, it is the legislature's authority to, have the power of the person to create the parameters of program. And then it is the executive branch's authority to execute programs that are created by law. And when they're not, when you just appropriate money but don't provide any sort of guardrails, I do think it is something that should cause institutional concern, because you could obviously take that down a logical pathway to a place where your ability to oversee how money is being spent and on what basis to measure not just outcomes, but whether or not it's consistent with your intent and with the enactment of law is no longer possible, because there literally is no statutory, metric or guardrail to assess against.
Yeah,
it's concerning to me.
Well, yeah, and it's concerning to me also, and it's not from a political standpoint, but as you say, from an institutional standpoint. The governor's veto message said, we worked on this bill last year, and we had the registry and the enforcement, and we had pieces that the governor really liked in terms of the VHIP program and the revolving loan program. And in his veto message, he basically said, I'm vetoing this bill. I don't like the enforcement mechanism or the registry, but I do like VHIP and the other thing. So I'm going to go ahead and go forward with those pieces. And it, as David describes, it is an issue. I think we all like these programs, and so they're going forward. But there could come a time where these programs are controversial, and institutionally, it sets a questionable precedent. So at the very least, I think what we will do in this committee is we will go over the VHIP, and to the extent the revolving loan program is functional, what the guidelines those programs are running under. And in this new bill, we might change those guidelines for those programs, because that's our job. Here's $5 million. I don't think it was ever our intent to say, here's $5 million for VHIP. You design it any way you want. I don't think the administration did that, but there may be things that we want to change in their design. So we will be talking about that as well. And I'm sorry we took so much time on that detour, but I think it's important for the committee to be aware of. David, are you pretty much done at this point in going through the bill?
I am. The only thing I'll flag, the last piece, is the effective dates, which at some point you probably will want to consider. Right now, this bill is all pegged to take effect legally in July of this year. And remember, the registration stuff doesn't happen until the following March. But that may be too soon for you or for others. So that's something to consider. And then the penalty piece doesn't take effect for another year after that. So July 1st, 2023. And then the exemption for farm housing is July 1st, 2025. It expires 3 years after the bill itself. So that's all I have.
Thank you. Great job, David. What I'd like to, does anybody have any questions for David before we move on before the break?
No, that was great. Thanks.
Okay. So what I'm going to do now is move to Sarah Carpenter, because I think Sarah has more history on this issue than anybody probably in this state. It's really frustrating how many years we've been working on this, and we sent the Rental Housing Advisory Board out to come make a recommendation. They work with all the parties. They came back with a recommendation they thought all the parties could agree to. They walked us through this in the last year, and we fine-tuned this bill to the point we thought all the parties could agree to. And I think a lot of us were quite surprised after all that testimony to wind up with a vetoed bill. It's a process issue that I'm very sensitive to now, and I want to know if we're going to have veto to the extent we possibly can. We know it before the fact, before we send the bill on its way, because I think we did a lot of accommodation in this bill only to find ourselves where we are now. So Sarah, can you join us? And the floor is yours.
Thank you. I'm always glad to see you, but not so happy to be back again. I thought I could shed this issue. Sarah Carpenter, chair of the Vermont Rental Housing Advisory Board, and have been working on this for years. And it's really very simple concepts. And this is, you're going to probably sense my frustration. This is not a complex bill. It really has, from my point of view, two main components. We have a housing code inspection program in the state of Vermont that is divided between two governmental agencies. The Department of Public Safety and the Department of Fire Safety inspect fire safety codes, building codes. About 70% of the codes fall under their jurisdiction. They do that with paid professional employees, and they do it on a complaint basis. The other 30%, which in fact are less complicated codes, but sticky, remain as an unfunded mandate for municipalities. They are required to find a way, hook or crook, to enforce those codes. Most often they use a volunteer town health officer who often is untrained to crawl around basements and deal with landlord-tenant issues and inspect these units. And it's created a system that just isn't working. Towns can't recruit town health officers, which by law defaults to the chair of the select board. They're not in a position to do this. So we have a third of the system just really not working. And we have a lot of redundancy and inefficiency. And this is the part that really, if you look at governance, why are we having two governmental agencies effectively inspect the same unit? There's often they're together. It can be redundant. And it's just a terribly inefficient system. Or that third is not getting addressed at all, which is really the problem from the tenant point of view. So putting the inspection responsibilities under one agency makes perfect, efficient sense. The legislature, you all asked the Department of Fire Safety and the Department of Health to do a needs assessment to figure out what that would mean if fire safety took it on. So the administration's 2 state agencies did a very comprehensive needs assessment in 2019 and determined, because of the crossover, that if they were going to take the rental housing health code on and add it to their inspection list, they would need about 5 additional inspectors to do it. The rehab board did not interfere with that. They could have come back and said, we need 50 inspectors, but they did a very honest needs assessment. They consulted all the town health officers, and that was their proposal about what it would need to add on. And it made perfect sense. And you can look at the needs assessment that they proposed. The administration proposed the 5 inspectors. As we proceeded down the path, we did realize that obviously you're going to have to pay for those 5 inspectors. The current inspectors under fire safety, the building code and fire inspectors, are paid for with state general fund money or an existing source. This would be an ad. Right now, in about 25% of the units in the state, in about 12 municipalities, operate under a system where there's a user fee charged per unit. It's working very well in those communities. It seemed like a reasonable assumption that we could certainly do that at the state level to cover that additional cost for the 5 inspectors. The add-on for those inspectors and that program and a rental registry is somewhere around $1 million a year, more or less. So that's the size of the program. Right now, that responsibility is all dumped on the towns, and some pay for it, some don't pay for it. So it would be pulling back, as I said, an unfunded mandate from the towns and asking the state to add it to a robust inspection program they already have. But to me, that just seems so logical and so much more efficient than this 2-pronged system that we have. I see Karen Horn is here and she can speak to this. Some towns have embraced this, and if you want to embrace it and run your own program, you can still do that. But most of the small towns don't have that capacity. They don't have the staff to do it. And they're asking to be relieved of that burden. And that's really what we're proposing. It's really quite straightforward. And that is the gut of S79, is to coordinate the codes, put them in one spot, and use the professional expertise of the fire and safety inspectors who already are in the apartments to do the health code side of it. Along with that, we've proposed a registry, which has a 2-fold process. We have always wanted to understand where rental housing is in Vermont. Rental housing is a business, just like I was quoted as saying dog groomers and tattoo artists, but there's tons of mechanics. I mean, the Secretary of State has 85,000 businesses listed. Why would we not want to know where rental housing is? It's just a unique business. I said to someone, if I had a flock of volunteers, we could go to every town's grand list and probably get the equivalent information, but we'd have to go to 240 separate towns, and that clearly doesn't make any sense. If you look at what we're asking for, again, it's really quite straightforward. Where are you located? Who owns the building? How many units you got in it? It's not intrusive information. And there are so many uses for that kind of information. Certainly, we know there's a housing crisis, so just simply understanding where the rental housing is would be helpful. We certainly saw in Irene the need for that information. We saw it again with COVID and with some of the programs that have been implemented. Again, it's not intended to be intrusive. I hear comments like, oh, it's bureaucratic and landlords will leave the program. That just hasn't been the case in the towns that do it. I mean, St. Johnsbury, small town, implemented it a couple of years ago, and they've got high compliance. People are not flying out of St. J because they don't want to register their rental apartment. It's just not a bureaucratic thing. It's a part of doing business. So really, those are the two components of the bill, and we just see those as really logical, straightforward. In my opinion, should be non-controversial. The governor has raised issues about the language around complaint-based. It has never been our intent to move to anything else. The current law allows a complaint-based system, so we were fine with that. S79 did, in my opinion, did not add anything to that. There were parts of S79 that, and this may have been confusing, repeated current law, so it may have appeared to add stuff, but there was never an intent to add stuff. There are a few communities who have chosen by choice to do proactive inspections, and I think that's great, but that was not the intent that the state take on that. So we're open. When the governor first vetoed the bill, I very explicitly asked his attorney, point to where you think this is other than complaint-based, and we still haven't got that answer. David added his language, which I think is clear and straightforward and should address that. If there's something we're missing in the language, tell us, and I think that part can be easily corrected. So again, and kind of in sum, it's a two-part program. We're asking the state to take the burden from the towns on the rental housing health code. I think very modestly, because there's already so much redundancy and inefficiency by adding the 5 inspectors, and then a registry to help guide us around where rental housing is located. The short-term rental information, very originally we didn't have, but it became pretty clear to us that there's a lot of crossover. A lot of quote short-term rentals do rent for longer than 30 days, depending on the season, and that's perfectly understandable. And it too is a business, and towns and the state ought to know where those businesses are operating. We look at lodging establishments, which is by definition 3 or more units. So understanding where this is, again, should not be complicated. It really shouldn't be. And I guess that's sort of in a nutshell. I'm happy to answer questions. I actually reviewed our original recommendations, and they still hold strong. The premises hold strong. We're open to the language. We tried last year with adding things like exempting units that are not held out for public rental. Like if you're renting to a friend or one of your children, those would not be registered. So I think there are options. I think we're fine with the owner occupied. We don't see a lot of code violations typically in owner occupied, but there's still that opportunity. And I think there's 2 purposes of the registry. One is to it's just to understand where the rental housing is. And you might ask, well, towns that already have this, towns that already have these programs, just go to their grand list. And again, if we had the resources to go to 251 grand lists, we could do this. This is just simply a more straightforward way to get the information on directly. So I guess that is it. And again, happy to answer questions.
Thank you so much, Sarah. Long, strange trip. Does anybody have any questions for Sarah at this point? Senator Ballant.
Really just a global question, which is, Sarah, you've been working on this for so long. How do you keep your spirits up? We have tried and tried and tried, and I just appreciate that you're still at it.
Well, I may not be for longer, but it is fresh. I mean, it's just such a, and I retired in 99, and I said, oh, I'll just stick with it one more time.
Yeah.
We'll get it done. Well, And I, to be honest, again, the resistance eludes me. I mean, I get it that nobody trusts government. Believe me, I live in a city where nobody trusts government. But we're not collecting deep information. I can also get the same information on E911. I had a big discussion with one of your colleagues in the Senate, and she said, I don't want anyone knowing where my unit is. I went on there and I said, Senator, here's your units. I know exactly where they are. But we can't do that for 250 towns. And so organizing it in a useful, protective way makes much more sense.
Absolutely.
Senator Brock.
Yeah. I think
Randy,
you're on mute.
you're muted.
In the event that we don't have a statewide registry, or we have a statewide registry that is riddled with so many exceptions that is not and no longer a registry, what harm is done?
Well, I mean, if it's riddled with lots of exceptions, that in fact becomes an issue. So I think narrowing these exceptions are something we have to be quite mindful of and understand why are they exempt. So I would agree, riddled with exemptions then becomes problematic. I would hope we would not choose to do that. Again, perhaps there's another approach for a registry. Believe me, we've sort of tried them all. We've tried to be respectful of both the towns, the tax department, E911, try to approach using their databases judiciously and combining them. We have a history of housing. The Department of Health is supposed to have one basically targeted to lead paint issues, but we've not given them the technology to keep it up. They're really desperate. They're, to be honest, not in compliance with your own laws around lead prevention because we've given them no support on a registry. So this would take up another requirement that I think is critical, understanding where apartments are that have lead-based paint, and sort of fold it in. If we could have no registry at all, you could just go straight to an appropriation, which is effectively what you do with the fire safety programs. That would be a step forward, although I think you're missing a lot by not understanding where your rental housing is, both short-term and long-term. And again, it's, there's 80+ thousand units out there that are rented. I hear all the time about, oh my, this is going to affect the mom and pops. You don't know how many mom and pops are because we don't even ask that question. So to assume that most rental housing is mom and pop is just not accurate. The one exemption we added was owner occupied housing, and I can live with that. To be honest, we don't know how much that is because we don't have a registry, but we could live with that. I think people who own housing external to their own home, they've bought a business, they've bought an investment, and telling us the location of that does not seem onerous to me.
When we refer to the exceptions, and we're talking, as I look at the draft of S210, there are a number of exceptions relating to owner occupation, the number of units and so on, but many of those things seem flexible. Is it an owner-occupied property in which the owner is occupying it, but then goes to Florida for 6 months a year and doesn't occupy it? Do those things, is it your envision that they go in and out of the registry?
No, I think if you used it on the owner-occupied thing, if you own it, and that's declared as your primary residence, you would not be registered. So yes, you could go away to Florida and you would still not be registered. And actually, I think that was sort of always the intent. So we're trying to be open. And so if that's your primary residence and you have up to 3 units in it or on it, you would not have to register. And if you leave for 4 or 5 months and don't register it, that would still remain the case. All of those units are still subject to inspection, so that doesn't go away. Simply, you wouldn't be on the registry.
Senator Clarkson.
Thanks. Sarah, one thing that occurred to me is, the state Secretary of State requires all businesses to be registered. I'd be curious to look at what their exemptions are for mom and pop businesses. I mean, mom and pop is not defined in statute. So I have some understanding for small amounts of business, but again, we have to remember that rental housing is a business. When you rent anything, it's a business. You're expecting income, you're profiting from that income. And when it comes to the health and safety of Vermonters, it's critically important we maintain it. That's our responsibility as legislators, as much as we can, to protect Vermonters. I would remind us that we heard from other agencies within state government that having a registry would be really helpful with a lot of the planning grants they do, just understanding where people live and how they live and in what capacities, what they're paying. There just is, there's a lot of interagency knowledge that would be enabled by this registry, is what I remember hearing in our testimony last time. And that we spend at the moment thousands of dollars getting that information because we don't have a registry. So we don't have one place we can go to and find out what information we have.
That's true. And this is more of a sidebar, but DHCD every year funds tons of market studies. They do every 5 years this fairly massive needs assessment, and you're paying experts to essentially guess where the housing is based on census, and census at our level and our town size is simply not all that accurate. It just isn't. So again, understand, I mean, we know where every farm is, we know where every retail shop is. So it's just not an exception to anything that if you own a business, tell us where it is. That's all.
Thank you. So I'll just end. We'll take a 10-minute break, but I just want to end by saying I personally have a long history with this, not as long as Sarah in some contexts, but I worked as a lawyer representing low-income people on cases like this 45 years ago, where there were dilapidated housing and I couldn't get a hold of a town health officer, or the town health officer had a conflict of interest, or everybody was conflicted out in the town, and the system just doesn't work. And we're trying to find a replacement system that does work. And I keep getting, when I was on the Essex Planning Committee and the zoning board, the town health officer there, he must be 80 years old now. I keep getting emails. He says, you have to pass this bill. The system doesn't work using town health officers. So I'll just end with that. We'll come back at 11:30